Okay, so welcome everyone. I'm Sarah Cleveland. I'm the faculty co-director here of the Human Rights Institute at Columbia Law School, and we're really delighted to see all of you here. This is one of two events that we are hosting today about the US and the global conversation regarding digital privacy and data surveillance in what is now almost 2 years in the aftermath of the point at which Edward Snowden revolutionized our understanding of these issues back in June 2013. So, as you all know, we all know a lot more about at least what US intelligence agencies do than we did 2 years ago. And the same is true, at least with respect to some governments and some corporate actors around the globe. What Edward Snowden did provoked a national and global conversation about what privacy rights should mean in domestic legal frameworks and international human rights frameworks, what level of surveillance is necessary for national security, and how we reconcile those competing imperatives as a matter of law and policy at the national and international level. So to explore these issues, the Human Rights Institute, the Hertog Program in Law and National Security here at Columbia Law School, the American Civil Liberties Union, and the International Network of Civil Liberties Organizations have organized these two events. Today's lunchtime event is talking about the current state of the national conversation here in the US on these issues, and then this afternoon at 6:10 p.m. we will be hosting a roundtable discussion with leading privacy activists from various countries around the world. This is really a quite remarkable opportunity to bring all these people together, and we will also be serving boxed dinners as an added incentive on this snowy day to encourage you to come here. I'd like to thank the Just Security blog, which is live streaming this event, and I would also like to thank the ACLU for energetically helping us to organize this program. You will see an empty chair here. We have two guests who are essentially debating, having a cordial conversation about the state of the US conversation, specifically what would US surveillance reform look like from this point going forward, and do we need it? We are anticipating the arrival of Robert Litt, who is the General Counsel for the Director of National Intelligence. He is on a train somewhere between Newark Airport and here, and trying heroically to get here, and we think he actually will. But in the meantime, he seems to have ceded the opening statements to his counterpart, his worthy counterpart, Jameel Jaffer, who is the Deputy Legal Director for the ACLU and the Director of its Center for Democracy. He works extensively on issues of human rights, privacy, free speech, national security. He's been on the forefront of all US litigation dealing with the privacy and data surveillance issues in the post-Snowden era. And so it's a real privilege and pleasure to welcome Jameel here. Please join me in thanking him. So we've had a tremendous amount of information, sort of a torrent of information, disclosed in part by Edward Snowden and subsequently by the media and also by governments since June 2013. What do you think that the public should conclude from all the information that has been provided? Leave that one, I'll give you this one.
No, all right. Well, let me first just say thanks for hosting us here. And as Sarah says, there are a lot of privacy experts in the room from around the world, and so it's a particularly intimidating audience for me, and my boss is actually sitting in the front row. So I'll try not to get anything wrong. But I think there are two big messages that we can draw from what's been released over the last 2 years. The first is just the scale of, and I'm going to talk mainly about the National Security Agency and the U.S. debate, at least to start with. But the scale of the NSA surveillance, I think, it far exceeds even the fears of the critics, and that includes those of us at the ACLU. Before the Snowden disclosures, we took we had the idea that the NSA was engaged in broad surveillance under some of these authorities, but we really had no conception of what the agency was actually doing. And if you just think about some of the programs that have been disclosed, the one that's received the most attention here is the call records program. The NSA, every time you pick up the phone, the NSA is making a record of who you spoke to and how long you talked to them, what time you called them, every single time you pick up the phone. And that's true, not just for suspected terrorists and suspected foreign agents. It's true for everybody who makes calls on U.S. telephone networks. And that program alone, I think, is probably fairly described as, by many measures, the largest surveillance program ever adopted by a democratic government against its own citizens. I think that's an entirely fair description of that program. And it's only one of many different surveillance programs that the media have disclosed. The NSA was collecting for several years internet activity data analogous to the call records. It was collecting location information analogous to those records as well. And these were all mass surveillance programs. They weren't targeted at suspected criminals or suspected foreign agents or suspected terrorists. The idea was to collect information, and is to collect information about everybody. So that's the first message I think we can take from the disclosures. And the second one, which is not unrelated, is that the mechanisms that were meant to be a safeguard against government abuse and against government overreach have failed, and I think failed quite spectacularly. We have as you probably know, we have a specialized court, the Foreign Intelligence Surveillance Court, that was set up in 1978 to oversee government surveillance for foreign intelligence purposes. And that court was supposed to be a safeguard for individual liberty. And instead, it's basically signed off on everything that the agency, the NSA, wanted to do. The program I first mentioned, the call records program, which, again, is staggering in its scope, is a program that the agency adopted without an opinion from the Foreign Intelligence Surveillance Court. The court didn't even issue an opinion about the program until 2013, after the Snowden disclosures. And that is supposed to be the principal check against government overreach. And then the congressional intelligence committees, which are really the other, are meant to be the other pillar of oversight in this context. They too have signed off on everything that the agency wanted to do, allowing the agency to far exceed its statutory authorities, and maybe even more problematic, allowing intelligence officials to mislead the public about the scale and scope of the agency's surveillance. So I think those are probably the two big lessons. I think that they show what we've learned is that the NSA has too much power, and that the oversight mechanisms are broken, and that the kind of reform we need is not just sort of piecemeal, but systemic reform. And I'm sure that if Bob were here, he would agree with all of that.
Bob, are you listening?
Probably is, yeah.
So just as a follow on that, do you think we now know what we need to know about intelligence surveillance, or is there more to be learned?
I think that I have a mixed response to that. I think that the government actually deserves a degree of credit for the turn that it's made over the last 18 months towards transparency on surveillance issues in particular. Initially, everything we were learning was coming out from the news media as a result of the Snowden revelations or the Snowden disclosures. That's not true anymore. We're learning a lot from the government itself. The government is releasing information. They've created this Tumblr in which they post information almost every week. There's a new set of documents up there. And some of that information is being, the government has been compelled to release it because of FOIA litigation, but a lot of it, it's releasing of its own accord, and I think it deserves a degree of credit for that. I will say that the disclosures are still highly strategic, that the kind of information that the government is releasing is the kind of information that the intelligence community believes will cast its activities in the most favorable light. And the most crucial information, even if it's in some ways the least likely to disclose sensitive intelligence sources and methods, the most crucial information is still being withheld. And I'll just give you, one example. In criminal cases, the government is now disclosing to criminal defendants when the evidence in their prosecution was obtained or derived from this particularly controversial surveillance statute, the FISA Amendments Act of 2008. And in theory, that should give criminal defendants the opportunity to challenge the constitutionality of that surveillance and to move to suppress the evidence that's derived from the surveillance. But in practice, what happens is that the defendant is told that information, but then also told that you can't have access to any of the underlying materials. You can't have access to the affidavit that we filed in order to get the surveillance authorized. You can't have access to the court's order that authorized the surveillance. You can't have access to the minimization procedures, which are the procedures that are supposed to, in some sense, limit the government surveillance. The defendant doesn't have access to any of that material. And in some ways, that's actually from an intelligence source and methods perspective, I think much less sensitive than many of the things that the government is releasing. But the government is withholding that information because that information would allow defendants to challenge the constitutionality of the government surveillance activities. And so, I guess the short answer to your question is that we certainly know a lot more. Much of the most important information, unfortunately, is still withheld.
So you mentioned the call records program, and you also mentioned the issue of constitutionality. So the call records program has obviously been the focus of much of the discussion within the United States because it affects millions of American citizens. And there are challenges to its statutory validity and also its constitutionality. As these issues are worked through, what difference will it make if those statutory and constitutional questions are resolved in favor of the NSA on the one hand versus the privacy litigants on the other?
Well, so I'm not sure how closely people have been following the litigation over the call records program, but the government's main argument, the main defense of this program, relies on a 30-year-old case called Smith versus Maryland, a 1979 case called Smith versus Maryland, in which the Supreme Court said that the Fourth Amendment wasn't engaged by the government's surveillance, their tracking of a single person's call records over a period of a few days. There's a criminal suspect, and the government installed a pen register on that person's phone and tracked the person's calls over a few days. Just the metadata, not the content of the calls. And the Supreme Court said that doesn't violate the criminal suspect's reasonable expectation of privacy. The government relies on that case for the proposition that the Fourth Amendment is indifferent to the NSA's collection of hundreds of millions of people's call records indefinitely. The government's theory, and I'm sure Bob will expand on this if he shows up. The government's theory is essentially that 0 plus 0 equals 0. If you surveil a particular person for a few days and get his call records for that particular period, and the Fourth Amendment isn't engaged, then the Fourth Amendment isn't engaged if you're doing that to hundreds of millions of people, and it's not engaged if you're doing it, for 10 years rather than 3 days. We have a different reading of Smith versus Maryland. To me, it seems crazy to think that the Supreme Court decided in that case that a program on this scale would be, wouldn't implicate the Fourth Amendment at all. But it's really, the litigation isn't really only about the call records program. I mean, it's the call records program that's before the court. But really what's before the court is the whole concept of collect it all. This is probably the most, I think, revealing document that's been released over the last 2 years. It's a slide, and at the top of the page it says something like NSA's collection posture. And then right underneath that it says collect it all. And That's probably a good summary and a fair summary of what the NSA has been trying to do, at least over the last decade. Essentially collect all the information, and that's predicated on the theory that the Constitution doesn't care about the collection of information. That the Constitution is engaged, if it's engaged at all, only when the government taps into its databases. So the theory that the government has is that they can collect all the call records, they can collect all the location information, they can collect all the all the URLs that you visit online. All that kind of information can be stored in government databases, and the Constitution doesn't care. The Constitution cares only when the government taps into those databases. Now, this is a very important issue. It goes way beyond the call records program, obviously. It relates to all these other sorts of records, and it relates not just to metadata, but to content as well, because if you accept that theory, there's no reason why the government couldn't record every phone call, copy every email, and then answer to the Constitution only if and when it decided that it wanted to look into the database. So really, this, the litigation is nominally about the call records program, but in some ways it puts the entire philosophy at issue. It really does sort of tee up that question.
So let's talk about the courts a little bit, since you mentioned the litigation, and I have a sense of what the answer to this question is going to be, because you referred to the spectacular failure of oversight by both the FISA Court and Congress in this context. So are the federal courts, are the FISA Court doing what they ought to be doing in this context? If not, what should they be doing? And does there need to be reform in that area? And how much is this a problem of law simply not keeping up with technology?
Well, I think that you probably accurately predicted my response. I don't think the courts are doing what they should be doing, but I think that things have changed quite a bit over the last couple of years. So if you, I was litigating these kinds of cases before the Snowden disclosures, and many other people in the room were litigating these kinds of cases before the Snowden disclosures, and at least in the United States, we kept getting kicked out of court at the threshold. Before courts would reach the merits, or rather than reach the merits, what courts would do is say that you can't establish your right to be in court, you can't establish standing, because you can't show to a certainty that your clients were actually monitored under the program that you're challenging. Of course, nobody could show to a certainty that their communications were monitored. The whole system was designed to keep that kind of information from individuals. And so the effect of that standing rule was to keep challenges to government surveillance out of court and to insulate government surveillance from judicial review. And when you could come up with a standing theory that would get you into court, you faced a different obstacle, sort of the flip side of the same coin, which was state secrets, because the government would make the argument, justifiably make the argument, that some of the details about the surveillance program you were challenging were sensitive and were secret. Justifiably may be too generous a word there. Certainly justifiably argued that they were secret. So those are sort of two threshold bars that we faced over and over and over again. And we had this case on behalf of Amnesty International and a whole slew of other human rights organizations and legal organizations and media organizations. And we lost on that ground, on standing grounds, in the district court, and we won in the Second Circuit, and then we lost 5-4 before the Supreme Court, just months before the Snowden disclosures started hitting the press. But that was sort of that was par for the course before the Snowden disclosures, and in fact it was par for the course even before 9/11. There are cases from the 1980s, 1970s, and 1980s in which political protesters tried to go to court, did go to court, trying to challenge government surveillance of their activity, which is protected by the First Amendment. And the court essentially said that either you can't challenge these programs because you can't show to a certainty that you were affected by them, or that the kinds of harms that you're pointing to, like the chilling effect of government surveillance, are not the kinds of harms that the courts will care about. And that was the landscape. It was a very bleak landscape before the Snowden disclosures. And I wouldn't say that the Snowden disclosures have changed that landscape radically, but the kind of fight that we're in now with respect to the call records program is one that we never could have had 3 years ago. Well, first of all, we didn't know about the program, but even if we had known about the program at some level, we wouldn't have had the details about the program. We wouldn't have known who was targeted by it, and obviously everybody's targeted by it in a sense, but we wouldn't have known that. Now we have enough information about the program that we can walk into court and get a judge to hear the case on the merits. And now three district court judges have heard the case on the merits, and the issue is pending before 3 courts of appeals in the Ninth Circuit, in the D.C. Circuit, and in the Second Circuit. We could get decisions every day, any day. But one thing that I feel pretty sure about is that one or more of those courts will reach the merits. And we may be disappointed with the decision on the merits. We'll see. But it is something significant that we are having this conversation that we've been wanting to have, when people before us were wanting to have in the 1970s and 80s, about the merits of the government surveillance policies. Are these surveillance policies constitutional? And you would think that would be the conversation that we would have in the courts, but it's only now that we're starting to have that conversation.
And what about the FISA Court? So is there a possibility for improving the FISA Court, expanding its jurisdiction, restructuring it in some ways that would make it more effective? Or do you think that the idea of having a court that tries to exercise oversight in secret is just fundamentally misconceived?
I actually wish that Bob were here for that question, because I'm really curious to know his view on that. Maybe he'll arrive in time to provide it. But when the court was set up in 1978, it had a very different role. The court basically heard applications for government surveillance, for surveillance warrants in individual investigations. So the government would go to the court and say, here's a person we believe to be an agent of a foreign power. This is why we believe this person is an agent of a foreign power, and this is the foreign power that he or she is connected to. And here is the specific surveillance we want to engage in because of that belief. And the court would say yes or no, usually yes. It didn't look very different, though, from what goes on in ordinary Article III courts, every day in criminal investigations. In criminal investigations, courts hear applications for surveillance orders ex parte. Only the government appears before the court. The whole thing is secret, and so in that, in its original form, I don't think that the FISA Court was such a departure from what we already had. Now the FISA Court is playing a very different role, because what the FISA Court is doing is approving not individualized surveillance, but instead approving vast programs of surveillance, like the call records program or the internet activity program or the location data program, these kinds of programs that are not targeted at specific people, but are instead forms of mass surveillance, or even under the FISA Amendments Act that I referred to earlier, the 2008 law. What the government considers is not whether any particular person is a foreign agent. The government doesn't have to show under that law that the target is a foreign agent. The only requirement is that the person be outside the United States, the target be outside the United States. If the person is outside the United States, the government can lawfully target that person so long as it believes that the communication will include foreign intelligence information, which is a very broadly defined term. And the role of the court is much, much different, because the court isn't considering the identity of the specific target or the reason to believe that that person is a legitimate target. The only question that the court is considering is whether the government's procedures generally meet certain statutory requirements. Like, for example, do the procedures ensure that the targets are in fact people outside the United States? And the court reviews the government's minimization procedures, which are, again, procedures meant to limit the intrusion on the rights of third parties. The limitations are actually very, very weak. They don't significantly limit the intrusion on third parties, but that's the idea of minimization procedures, and that's the court's role, to consider these broad programs of of surveillance and the broad procedures associated with those programs. And I think there, the implications of having a secret court decide these kinds of questions in a non-adversarial process, I mean, I think it's a completely different thing. And it's not something that Congress signed on to in 1978 or that the American public signed on to in 1978. This is a much more recent development. And it doesn't make any sense to me to have a secret court decide in a non-adversarial process the kinds of constitutional questions, these hugely significant constitutional questions that have implications, not just again for suspected terrorists and suspected foreign agents, but for everybody. It's not just that. It's not just that it's unfair in a sense that only the government appears and so the other side isn't represented. I mean that's obviously true, but it's impossible. I'm just stating the obvious to have a public debate about this kind of thing. If the public doesn't know what the government is proposing, at least at some level of generality, it's impossible to talk about whether it makes sense for the government to collect everybody's call records. Forget the constitutionality, forget the statutory authority. Just the political wisdom of this kind of decision isn't ever subjected to democratic debate. And a few of us actually, as part of this larger convening, had the opportunity to talk to Ed Snowden this morning. And this is one of the things that he emphasized, I think, rightly, that the point of these oversight mechanisms was to ensure that the intelligence agencies operated with democratic consent. And they have, I think, plainly failed to do that.
Are all of the U.S. surveillance programs subject to FISA Court oversight?
No. No. Actually, just the tip of the iceberg is subject to FISA Court oversight. The programs that most directly affect the rights of Americans, some of those programs are subject to FISA Court oversight. But many other programs aren't, and the programs that have the greatest implications for people outside the United States are not subject to FISA Court oversight. And I think that Bob and I are on the same page about everything I've said so far.
I agree with everything you said except when I disagree with it. Sorry I'm late. Amtrak was not reliable this morning.
So now let me formally welcome...
Don't take any pictures until I've got the red out of my cheeks.
Robert Litt, who, as I said previously, is the General Counsel for the Director of National Intelligence. Bob has held a long and illustrious career both inside and outside of government. He was a U.S. attorney here in the Southern District of New York. He worked for a period of time with the law firm of Arnold & Porter. In the Clinton administration Justice Department, he was the Deputy Assistant Attorney General in the Criminal Division, and then later the Principal Associate Deputy Attorney General, and in that capacity was responsible for addressing, among other issues, or in those capacities, issues relating to computer security, FISA applications, and some of the issues we're discussing here today. So as I said, you've done a magnificent job of getting here. All other lunch speakers canceled, so we really, really appreciate it. Please join me in welcoming Robert Litt. So we are live streaming.
Okay.
With Just Security, and Jameel has answered all of the questions that...
Wrongly.
So we've said a little bit about the impact that the Snowden revelations have had on the public conversation, what the public's takeaway should be from the Snowden revelations, the call records program, and its statutory and constitutional legality, and how the courts should be thinking about those issues. Jameel talked some about the increased disclosure by the U.S. government in the last 2 years of various forms of records. And we were just discussing the issue of judicial oversight, and in particular the issue of FISA Court oversight, and whether or not the FISA Court, as originally conceived and structured, was really intended to address and is capable of addressing appropriately the kinds of questions that are being put to it now. So that should give you a little bit to talk about.
Okay. What do you want me to talk about?
Whatever you want. Why don't
Okay.
you say a little bit about what the government has done since June 2013?
Okay, well, in terms of lessons to be taken away from Snowden, I think that one thing that has been brought home is that, in fact, we do need to be more transparent about the authorities under which we operate and our use of those authorities. There was actually some debate about this internally within the executive branch that was prompted, that preceded Snowden and was going on for a long time. But there is an inherent problem because if you talk too much about intelligence activities, you lose the capability to do those intelligence activities. And so it's a difficult line to draw. I think that we have all come away from this with the lesson that we're not going to be able to keep the public's trust if the public doesn't have some understanding, at the very least, of how we're interpreting the authorities and the kinds of oversight that exist over the programs that we are carrying out. And I think that while it's a time-consuming and resource-intensive process to go through, for example, FISA Court's opinions and separate out the portions of those opinions that deal with specific intelligence sources and methods, specific targets of intelligence, specific intelligence collected, and so on, so that we can release the legal authorities portion. It's something that we're working on and we're continuing to work on. I happen to personally feel that if we'd found a way prior to Snowden revelations to disclose the fact that we were interpreting Section 215 to permit bulk collection under the kind of restrictions that have been applied to that program, that there would have been considerably less controversy about it. I don't know, what else? In terms of the legality of...
Can I ask you a question
Yeah,
about
yeah,
that, Bob?
yeah.
So let me talk
Yeah,
to them.
yeah.
So is the implication of that if there are other surveillance programs going on now that are analogous in some loose way to the call records program, that we should feel confident that the intelligence community would disclose that to the public?
Well, I'm not sure that what you mean by analogous to the 215 program. There's a whole range of intelligence collection activities that go on, most of which are, as you know, carried out overseas and with relatively, and I use the word relatively advisedly here, relatively lesser impact on U.S. persons. We're going through everything we do and making a determination of what can we inform the public of about these programs without compromising our ability to do them. I mean, I will say, as I've said in many forums before, that nobody should be under any illusions about whether or not Snowden's leaks have done damage to our national security. They clearly have. We're never going to be able to point to a specific plot that we were unable to stop because of Snowden's revelations, because the fact is we don't know what we don't know. What we do know is we see specific instances of terrorist groups talking about Snowden's revelations and saying we have to change the way we communicate because X company works with the NSA, for example. The company was named, but I won't name it here. And so these are definitely going to have a damaging impact on our ability to protect the nation. And so going forward, we've got to make sure that what we disclose does not have a similar impact or have an adverse impact. That's not an easy thing to do, but yes, we are, I think, generally committed. The DNI recently issued a set of transparency principles, which are at a fair level of generality, but they're intended to guide the community and to try to get proactive in what we disclose. On the legality of the 215 program, I mean, obviously, this is something that's now going to be settled by the courts, perhaps with or perhaps not with an assist from Congress, depending upon what happens over the next few months. I don't want to go into a long discussion of things that anybody who's interested in can find the briefs online and read the issues, but I do think it's relevant that of 20 some odd judges who have reviewed this program, exactly one has found it illegal. And the others have all found that it was both consistent with the law and consistent with the Constitution.
I think I need to respond to that. So,
I was going to let you.
I mean, Bob knows what I'm going to say. So, most of those judges had only the government appearing before them. But I'm not even sure that, even if you just measure it by the judges who've heard the case in adversarial proceedings, I'm not sure that's the right measure either, because since the disclosure of this program, two presidential review, or the Privacy and Civil Liberties Oversight Board and the President's own review group have concluded that the program is ineffective. And the President himself has concluded that the program is unnecessary. And so even if you sort of leave the weedy legal fight to the side, I think that alone shows that the oversight mechanisms failed. Because why do we have a program on this scale? It was a huge departure from the kind of surveillance that was going on, at least inside the United States before. Why do we have a program on this scale if it's not even if the President himself concedes that the government's interest can be accommodated much more narrowly?
Jameel and I could go on about this all day. We have, in fact, in the past. But let me just say that on the issue of the efficacy of the program, I think that people have been applying the wrong standard. As I've said before, you presumably, if any of you out there has a house, you have a fire insurance policy on that house, and you have that fire insurance policy in case something happens. You don't look at the fire insurance policy and say, well, there's never been a fire in 5 years, so I think I'm wasting my money on this, I'll throw it away. This is an insurance policy to try to prevent a gap that we know existed prior to 9/11, because we have a specific instance of a case where we could not identify one of the 9/11 terrorists being in the United States because we didn't have this capability. What the President has said is he thinks this is an important capability. He thinks the capability needs to be preserved in a way that does not involve bulk collection, and that requires legislation, which Congress has so far been unable to pass. Legislation which Jameel and I both are willing to hold our noses in support, though it doesn't give either of us everything that we want.
So that's a good entree, I think, to the actual title of the program, which is, do we need surveillance reform? And if so, what should it look like? And then I'll have a follow-on question about, are we likely to get it? But the government has made a number of changes already. Do we need more surveillance reform, do you think, Bob? And if so, what would it look like?
I'll let Jameel have the first crack at that.
Well, I already said that I think that we need not just reform, but fundamental, systemic reform. And there is this debate going on right now about reauthorization of Section 215 of the Patriot Act, which is the provision that underlies the call records program. And I think that it's good that we're having this debate. And we supported legislation the ACLU have supported legislation that would significantly curtail the government's ability to conduct bulk surveillance, mass surveillance under Section 215, and a few other provisions as well. I think that has to be just the start of the conversation. These kinds of domestic metadata programs are again just the tip of the iceberg. The NSA, we now know, is combing through I don't even know, billions of communications every day. Not just the metadata, but the content as well. And that's not just Americans' international communications, but many foreign-to-foreign communications as well. And there hasn't even really been a debate here yet about how to reform those things, what kinds of constraints make sense. There is one proposal on the table which I think is a very good one, but again, only a partial solution. Some senators, including Senator Wyden, have championed an amendment that would solve something that has been called the backdoor issue on the FISA Amendments Act. The issue here is that the government collects huge volumes of Americans' international communications in the course of targeting people outside the United States. And as I said earlier, I have a problem with the targeting of anyone outside the United States in the first place. But even if you accept that as a legitimate activity on the part of the NSA, the surveillance involves the collection of huge volumes of Americans' communications as well. And Senator Wyden has proposed that there should be judicial oversight before the government taps into that database of Americans' communications that were collected incidentally, that's the word that they use, incidentally in the surveillance of people outside the United States. So again, I think that's only a partial solution. It doesn't even get at the targeting of people outside the United States, which is far, far too broad and in some ways the biggest problem here. But it is, it would be a step in the right direction.
So with your permission, I have 3 levels of response I want to give to this. The first is to, I'm struck by your statement that you have problems with the targeting of people outside the United States, and of course I missed that. So tell me what it is, bearing in mind that we're talking about the collection of foreign intelligence here, which is far more regulated in the United States than anywhere else in the world. What is it about targeting non-Americans that troubles you?
Yeah, I didn't mean to suggest that the government shouldn't target anyone outside the United States. But the targeting procedures, as you know, don't require the government to show to anyone or even to believe that its foreign targets are suspected terrorists or suspected criminals or suspected spies. They don't have to. The government doesn't have to show or have a belief about the status of those people at all beyond the status of being foreigners outside the United States. The only real constraint on the government's authority to monitor those foreigners outside the United States is the government's belief that the communications include foreign intelligence information. And that phrase, I said this before you got here, Bob, that phrase is very broadly defined. And there's nothing in that phrase that would preclude the government from targeting, for example, a human rights researcher outside the United States or a journalist outside the United States to collect information about, for example, unrest in some third country. And I think that kind of surveillance will inevitably have a huge chilling effect, even apart from the privacy intrusion, a huge chilling effect on activity that we all value. We want people to be able to dissent, to associate in order to dissent. And those kinds of activities are not possible if you have this kind of pervasive government surveillance. And just, I want to agree with you on one point, though. You made the point that the United States may not be the worst actor here. That's not the way you put it. But I actually agree with that the United States may not be the worst actor here. But the United States has far more power, far more technological capacity than most of the other actors.
So just 2 points to make in response to that, or 3 points. The first is to remember that the collection of foreign intelligence is historically a sort of a prerogative constitutionally assigned to the president. And so that's the way the Constitution allocates responsibilities here. And it's not true that there are no restrictions on it. One of the things that we have done in the last year and a half is imposed a set of both procedural and substantive requirements. I would grant they are not overly restrictive, because you don't necessarily want to have too much restriction on foreign intelligence collection. But there are principles that says we can't target people for the purpose of suppressing dissent or burdening speech. We do have to document a foreign intelligence purpose for collection. There is oversight within the executive branch of this. And the third point I'd like to make with respect to the chilling effect is that, with all due respect, if a foreign human rights official is worried about the United States targeting them as opposed to all the other bad actors out there, and that's what's chilling them, they're not being very realistic. They're at far more risk from other countries than they are from the United States. But I said I had 3 levels of response. I want to go on to the second one now, and that is with respect to the specific provision Jameel talked about with respect to the Section 702 program. It's important to understand that incidental collection of information occurs all the time. Example I like to give is if you are sending emails to a friend of yours and your friend abandons his computer and the government comes into possession of that computer, there is nothing to stop the government from looking for your emails on that. If you are talking to somebody who turns out to be a government informant and he decides he wants to tell everything you said to the government, you have no right to block that. The general rule is that if information lawfully comes into the possession of the government can use it. And The fact of the matter is this is information that is collected by targeting non-US persons. Congress knew at the time it passed the statute. It was perfectly clear that there were going to be US persons information collected, and as a result of which, Congress required that there be minimization procedures to protect the identity of those US persons before any information about them is disseminated. And this strikes me, and it strikes the judges who have reviewed it so far, as being a reasonable constitutional balance. The third point I want to make is to take this up a level of generality. There's a lot of discussion in recent Supreme Court cases about the concept that our Fourth Amendment protections have to adapt to technological change, and the doctrines that existed or that were developed 30 or 40 years ago before digital communications and the internet need to be revisited now. And I think that's absolutely right. But I think it's a two-way street. I think we also need to look at the question of privacy and how we protect it. And so what I would ask everybody here, but particularly Jameel, is to imagine the following hypothetical situation. And this is taken in part from the facts as alleged by the plaintiffs in a case out in San Francisco, which the government recently won on standing grounds. But let's assume that the NSA wants to scan every communication, every electronic communication going into or out of the United States for malware, to detect hacking or cyber espionage or another thing. And the only way to do that, because you don't know who's sending the malware, is to put an electronic sensor that scans every single electronic communication, all of your emails, everybody's electronic communications. But let's assume that the only ones that the electronic scanner pulls are ones that in fact contain malware. Everybody else's communications go blithely on without being intercepted. And let's further assume, and this is where Jameel's going to disagree with me on the factual premise, but we're doing what Einstein used to call the thought experiment, so let's assume this is true, that we can be sure that that is the only thing that is done with this, that all that happens is it's scanned for malware and things that contain malware are pulled out. Is that, in your mind, in Jameel's mind, is that a violation of privacy?
I don't know. I think it gets harder if you are looking not for malware, but for keywords or selectors, as the NSA sometimes calls them, right? I think that the constitutional question gets harder. I just want to go back to something, Bob, that you said earlier, though. Sorry, I'm not engaging your hypothetical. I don't have anything interesting to say about it.
But
maybe it is, maybe it's not.
I will follow up on it.
All right. So, and I know. I've heard Bob say hypothetically enough to know that something like this, if he says it's hypothetically going on, is probably going on. But
no, in fact, you should make no such assumption. I'm a lawyer. I deal in hypotheticals.
You made these arguments about the incidental over here line of cases, right? You say, well, it's long been accepted that if the government has the authority to surveil one person, then they have the authority to surveil that person's communication with others. So if they're targeted, if they get a warrant to target Ben Weisner, who's sitting up here, then I can't complain if the government collects my communications with Ben in the course of the government surveillance of Ben. And Bob's right about that. There's a whole line of cases that say essentially that. But the implication of accepting that theory in this particular context is that Americans have no expectation of privacy, no constitutionally protected expectation of privacy in their international communications. Because Bob's theory is that the NSA can target people outside the United States without reference to the Constitution, because those people don't have constitutional rights to assert. Right? We can target anyone we want to outside the United States. The Constitution has nothing to do with it. So we target a lot of people outside the United States. And in the course of targeting those people outside the United States, we collect their communications with Americans inside the United States. And I say to Bob, well, now does the Constitution care? And Bob says, no, it doesn't care now either, because once the information is in our possession, the Constitution has nothing to say about the government's use of that information. Now, Bob gave this very long explanation of why the incidental over here cases support the government's surveillance practices in this area. And I'm not going to engage, whether he's right about the cases or not. But I want everybody to be clear on the implication of accepting Bob's theory. The implication of accepting Bob's theory, or the necessary result of Bob's theory, is that Americans have no constitutionally protected right of privacy in their international communications. And that's the debate we ought to be having, not this debate about these weedy constitutional cases from the 1970s.
So Sarah says she wants a couple of audience questions, but I'm going to just respond briefly. I think that Jameel's unwillingness to engage in the hypothetical is significant, because I do think the point I'm trying to make is that I think we need to think about privacy in terms of ensuring that we have adequate restrictions on the use of information that government collects. All this information we're talking about, it sits on Microsoft servers, it sits on Google servers. We are much more, the reason we are uncomfortable with it sitting on government servers is because we're concerned about what the government can do with it. And so the question is, the challenge for us is, can we develop sufficient technological and legal and procedural controls so that we're comfortable that information is only being used for proper purposes? With respect to the incidental collection point, I disagree with the way Jameel frames the issue. It's not that you have no expectation of privacy. The question is always, how can the reasonable expectation of privacy that you have be overcome? Under what circumstances can it be overcome? In the court, and so, for example, if you're talking with somebody who turns out to be a mafia don, and there's a probable cause established as to that mafia don, but not as to you, it's not that you have no expectation of privacy in the conversation because there's a wiretap on his phone. It's that under certain circumstances, that expectation of privacy can be overcome. And so I would agree with Jameel, there is a lesser threshold by virtue of its being an international communication than there is for a wholly domestic communication, but that's also not novel in the law. There are lots of circumstances in which things crossing the border have a different expectation of privacy. If you are entering the United States, you're subject to search without a warrant simply by virtue of crossing the border. So it's not no expectation of privacy, it's a lessened expectation.
Okay, so we have 6 minutes. I'd like to collect a few questions from the audience and then turn it back to both of our speakers, and please try to be brief. Yes?
This actually won't be popular in a law school setting, but I'm wondering if this litigation over whether a specific program is legal or illegal frames the conversation as too binary and doesn't allow us to ultimately get to a conversation of what is the proper balance between the two. Because right now I have to accept that one of you is right and one of you is wrong, as opposed to thinking, well, what is the right way for the government to go about doing this while also protecting our privacy?
Okay, then maybe you also.
I had a question for Robert Litt about Section 215. If I heard you right, Mr. Litt, you had sort of two supports for Section 215. One was the fire insurance analogy, and one was what I believe is the Midyar case from 9/11. So my question is, the Midyar case happened more than 13 years ago, and the fire insurance analogy case is sort of, we need to do this even if something never happens. My question is, 50 years from now, can you imagine any set of circumstances under which someday the Section 215 metadata program would not be necessary, or does it just need to go on forever?
Okay, one more question, please. Yes?
I just had a brief question with regards to the context of intelligence sharing and the possible ramifications of that. I will use the example of the context of the fight against terror, where we've had examples of renditions or extrajudicial executions. What existing obligations are there with regards to looking at the far-reaching ramifications of intelligence sharing within that context? And are there any lessons learned from that and prescriptions for reform?
Okay, you've each got 2 minutes.
Oh, great. So on the first question, you'll make a good lawyer. I commend you, if you are not already familiar with it, a book by Jack Goldsmith called The Terror Presidency. Jack Goldsmith, who was the head of OLC in the Bush administration, who makes the point that he thinks one of the reasons our counterterrorism policies got into trouble after 9/11 was that there was entirely too much focus on what was legal and not enough focus on what we ought to be doing. I think that's absolutely right. And I think that applies here as well. I don't think Jameel would disagree on that. I think that that it is, and I think the president agrees with that as well. And if you look at some of the statements and the policies that have been issued with respect to surveillance, it's perfectly clear that we're being asked to determine not only what's the full extent of legality, but what's the appropriate limits on surveillance. On your question about 215. I guess I have two answers. My guess is that the technology will far outrace the 215 program within 50 years, so that's a question that will become meaningless. But it's also important to note that in my view, something with which I know Jameel disagrees, what we're talking about something here is a program that involves a very minimal intrusion on privacy and very stringent controls to ensure that it's not misused. So to carry my fire insurance analogy forward, it's a relatively cheap fire insurance policy in terms of the privacy costs. On the last question about intelligence sharing, we do have rules about that we can't share intelligence with nations where they know they're going to use it for an improper purpose, including violations of human rights and so on. That's something that we take into account all the time in determining what intelligence to share with which foreign governments.
So Bob used the phrase, the privacy cost is cheap, I think, for the 215 program. You know, I think that the privacy cost is largely invisible, and that's part of the problem. If you imagine, that instead of this particular program, the government had a program under which everybody had to, at the end of each day, report to an office in their neighborhood with a log of the calls they'd made. You have to write it down. You know, as you're going through the day, when you make a call, you have to write down who you called and how long you spoke to them for, what time you made the call. You have to show up at this office at the end of each day. I think that there would be a huge outcry, not about the burden, not about the fact that you have to go to the office every day, but about the privacy intrusion. It would just be much more real to people. And I think that part of the reason that there hasn't been as large an outcry about all of these surveillance disclosures as one might have expected is that the cost, the privacy costs, are somehow made invisible by the fact that they happen in this digital realm. And people just they don't seem real, but they are very real. And I think one of the questioners, sort of points this out. They can be very, very real because this kind of information is used in all sorts of ways. It's used to put people on no-fly lists. It's used to deny them security clearance. It's used by other governments to carry out lethal operations. It's used by our own government to carry out lethal operations. So maybe invisible, but it's very real. And then just very quickly in response to the first question or comment, I totally agree with that. I think that this is a larger cultural point that you're making. I don't think it's limited to the surveillance sphere. We have this habit of focusing on the legal question. There's a forum in which you can debate the legal question. I think that's part of it. And we very easily slip into the notion that the answer to the legal question is the answer to the policy question and the answer to the moral question, that they're all sort of folded together, which is obviously not true. And I think that it's a good thing to resist that. Whatever the answer to the legal question, there is a second question about whether it's politically wise to do this, and a third order question about whether it's moral to do the kind of surveillance that we're doing, especially outside the United States.
Great, so I think that actually beautifully tees up the second program that we're holding today at 6:10 p.m. here in the law school in room 106, when we're having a roundtable discussion with privacy advocates from around the world. We'll be taking the conversation to the international level, looking at not only international law issues, but also issues of how other countries have been impacted by the US revelations, issues of sharing of intelligence, and also what other countries are doing and the extent to which those practices are also under scrutiny. Obviously, other countries may not have the same technological capabilities as the United States, but they may also not have the same kind of procedural and substantive constraints either. So with that, we could continue for a long time, but please join me in a big round of applause for our speakers.